So with that being said, we mentioned 3 major rights of the wife as well last week. And the first, just to kind of quickly go over it and review, the first of those 3 rights had to do with ḥuquq al-maliyya, or financial rights. And financial rights were divided into 2 sections. The first was the mahr. The mahr, which is due upon the husband from the time of the signing of the contract, unless if otherwise stated and agreed upon by both parties that there's going to be a portion or all of it deferred to the future. Okay? And we also mentioned the permissible forms of mahr. And we said that the majority of the ulama considered permissible mahr to be something that has monetary value that can be associated to it directly or indirectly. And we also mentioned that the bare minimum could be anything that is even as insignificant as an iron ring or less, as we see in the sunnah. And the highest can be, well, there's no upper limit. It can be as high as the man wants to give in order to basically marry that particular woman. And one thing to just add on to that is the ideal mahr. What is the ideal mahr? The Rasul ﷺ said in a hadith that is sahih, خَيْرُ الصَّدَاقِ أَيْسَرَ. The best sadaq or best mahr is the one that is the easiest on the parties that are basically giving it, easiest on the men. Even though a high amount can be given, it is best to facilitate the matter, to facilitate marriage, to facilitate the financial rights without causing burden on any particular party. And that's why the likes of Imam 𝗍𝗶𝗿𝗲, he said that the best mahr is again the one that is the easiest, that is as low as it can be, but it still fulfills the function of demonstrating a level of seriousness on the part of the man who's proposing. And if something is exaggerated, if the mahr is exaggerated, it is something that will reduce the barakah from the marriage. Because we said, as Allah subhanahu wa ta'ala mentioned, وَآتُوا النِّسَاءِ صَدُقَاتِهِنَّ نِحْلَةً, that the mahr is given nihla. Who remembers what that means? That particular term that we mentioned. The ayah in the Quran mentions, give to them a sadaaq, a gift, in a manner which Allah subhanahu wa ta'ala described as nihla. Nihla had 2 meanings for those who forgot to write it down. One is that it is an obligation. And the second is that it is a gift that is given out of generosity, out of good nature and happiness. It's not meant to be a resentful payment. And the only way that that can be ensured is if it's not excessive and if it's not burdensome just to get married. And subhanAllah, you see the mahr of the Rasul sallallahu alayhi wasallam, which was roughly about 480 to 500 dirham. And converted to modern day term, that will be roughly about $1,400 to $1,500 in CAD today. That was the average mahr of the Rasul sallallahu alayhi wasallam, with the exception of Habiba, who was given 4,000 dirham, but that was given by al-Najashi on behalf of the Rasul sallallahu alayhi wasallam. But the mahr that he gave to his wife sallallahu alayhi wasallam himself was no more than 500 dirham, as was narrated by the likes of Umar ibn al-Khattab. Now there is one aspect that I forgot to mention last week, and that is, who are the parties involved in determining the mahr? Because there seems to be a misconception that a lot of women feel irritated and they feel wronged when, for example, their father or their wali interjects and gives an opinion on the mahr as well. According to the Sharia, the mahr is determined by, it's a gift that is given by the groom-to-be to the bride-to-be, and it must be acceptable to the wali as well. Meaning the wali has an active interest in knowing and determining the mahr as well. And the reason why is to avoid the woman from being taken advantage of in this manner. So the wali has an active role to play in determining and finalizing the mahr as well. Part of the discussion that we just mentioned with regards to making mahr that is easy, that is not burdensome, and exaggerating, which is very common, especially in some cultures. They even will put a mahr amount that is very high, just so the community knows that this is the high mahr that was given to our daughter, even though the intention behind the actual amount is that the full amount is not going to be given. It becomes a show. This is something that is completely rejected by the deen of Allah subhanahu wa ta'ala. It's meant to not be a payment to purchase the woman. The woman is not a property to be purchased in that aspect. Rather, we mentioned that this is a gift for which there are many wisdoms behind it. Not really mentioned by the Quran and Sunnah, which is why the ulama have several wisdoms that they have highlighted. The main or the most oft repeated wisdom of this is to show the seriousness of the man in the endeavor of marriage. It's to show the commitment of the man, so that there is a cost, there is a level of effort. It is human nature that when something comes to us easily, we tend to basically belittle the value of it. So this is a payment that is meant to show a level of seriousness, but is never meant to be a burden. It's never meant to be a hindrance to marriage, which is why I mentioned the hadith of the Rasul sallallahu alaihi wasallam. The second aspect, or the second right of the wife, and therefore the responsibility of the husband, is nafaqah. Nafaqah, or provisions. And this is also part of the financial rights, where we mentioned 4 types of provisions that are due upon the wife from the husband. Who remembers those 4? Food and drink is the first one, yes. Clothing is the second one. Accommodation and lodging is the third one, the housing. And the housing specifically includes the place to sleep, so basically a bed. It includes a place to eat. It includes a place to cook food. It includes a place to relieve oneself to the call of nature. So basically a bathroom, a kitchen, a room to sleep in, and to do all of that within privacy. So this is, from a legal standpoint, this is a bare minimum that is required when it comes to the provisions, that there is one place, and it can be as tiny as like a corner, that has sufficient space to do all of those things. And we mentioned this is the bare minimum. So one relevant contemporary issue that we can see is that due to the high cost of housing, separate housing, it is very difficult for many, especially young couples, to have a separate place. So they have to share a space for a certain amount of time with, for example, their parents, the husband's parents. In that aspect, it is fine to do that as long as the wife-to-be agrees with that. Okay, because like we said, it is a right for her to have a place that accommodates all of those 4 things that we just mentioned: the place to sleep, cook, eat, to have privacy in a private bathroom, and so on and so forth, without having to interact with any non-mahram or anybody outside of the husband and her kids. But given the state that we're living in and the difficulties that we face in reality, it is very common to see a joint family system. Now, if that is the case, it is very important for especially the parents who are living, or the siblings who are living, to understand and respect the boundaries that each and every single person has. Similarly, the wife who is living in that kind of a situation also has to be cognizant that she is sharing the space. So the element of fearing Allah subhanahu wa ta'ala and to live with a level of patience is utmost important to have a healthy environment. Again, this is the challenge of the day that we have, and this is unfortunately one of the consequences of not having an Islamic system at the level of a society. And as a result, we're suffering. We all have to basically give up certain aspects of what we are owed, or what we are basically entitled to be given. And Allah subhanahu wa ta'ala knows best. But this was the third aspect, the physical accommodation and lodging. And then what was the last, or the fourth aspect? Sorry? Medical expenses. And medical expenses is something that the classical scholars did not consider to be provisions, by the way. The classical fiqh opinion amongst the 4 schools of fiqh was that the medical expenses were not part of provisions. But that opinion is no longer valid today. The vast majority, if not all of the ulama in the contemporary world today, will mandate medical expenses to also be covered by the husband directly or indirectly through the state. And this basically comprises the obligation of provisions. And subhanAllah, just as a side point that comes to mind, when we look at, for example, the ijab and qubul, when the nikah happens, who does the proposal and who does the acceptance? Okay, and then the acceptance is? So this is one of two opinions that the ulama have held. The first is what you said, the groom proposes and the wali and the girl accept. However, the second opinion among the four schools, which is also the opinion of the Hanabila, is that the wali is the one who is actually proposing, and the acceptance comes from the groom. Now why is that? Why is the groom accepting, according to this one of the two major positions that exist? The amana, beautiful. The nafaqa, the provisions. The wali is essentially saying that here's my ward, here's my daughter that I've been taking care of. Now it's time for you as the groom to take care of her. Do you accept? The husband or to be, the groom to be is the one who says, I accept. So again, this is tying to the right of provision. And this is a very interesting point on how the Sharia views certain elements that we might overlook, subhanAllah. And we mentioned that provisions, just to kind of finish the point, provisions are based on two factors. The first factor is the custom, what is considered to be normal in the relative culture and time. And the bare minimum will be basically what a woman needs to be safe. So for example, we gave the example of the winter, where in the winter she needs certain types of clothes in order to be protected. In the summer it will be something else. Also the bare minimum will be to be able to fulfill her Islamic duties as well. This is also part of provisions. And the second factor that we mentioned last week was the ability of the husband. So no man is going to be burdened beyond his capacity. So whatever standard of living the husband is able to provide the wife, that is the standard of living that has to be accepted by her as well, given that the bare minimum aspects are given. Nothing more than that to overburden the husband in that situation. So by kitchen we mean a place where she can cook without having to necessarily interact with anybody else other than her husband and her kids. This is basically the right of privacy, and that is included in the rights that are given. Living in a joint family where, for example, the bathrooms are shared or the kitchens are shared, this is not the normative ruling that is acceptable. This is fine if let's say both sides accept, given the circumstances and the reality that we face, especially today, where let's say you're a couple, you're 22, 23, they get married. At that age, it is nearly impossible to have a separate dwelling that can be afforded. So in that situation, are we going to tell the couple, don't get married or delay and have the possibility of engaging in sins? Not at all. We would actually recommend them to have a shared accommodation that they can live in temporarily until they're able to afford a place of their own to be able to have that. But in the interim period, they will have to basically share a space, and part of the rights that they are owed are going to be given up. Again, because of the nature of the situation that we're facing. The wali, no. So for the conditions of validity of a nikah contract, the majority will mandate a wali's permission as well. The minority with the Hanafis will not mandate that as a condition of validity of a nikah contract, but they will still mandate that as a very highly emphasized recommendation. Meaning the nikah contract, according to the minority, is valid without the permission of the wali, but that does not mean that his contribution is not there. It's still a very important matter to have within a healthy marriage. You want to have the family, the wali, the one who's taking care of his ward, the one who is responsible for it, to be on the same page as well. Also, there's one more question that was given last week, or asked last week, with regards to provisions, where there's a very common misconception where a lot of women think that they have a right over the husband's money, meaning, is his money her money? And the answer to that question is absolutely not. Everybody's money is theirs. That's why we have rulings, for example, with inheritance. If, let's say, we can just take someone else's wealth willy-nilly, what's the point of having clear-cut shares that are due upon others and to have clear-cut responsibilities with regards to spending money? So no, absolutely not. Now, if, for example, the husband is not fulfilling the bare minimum requirements of the wife, then what does a woman do in that situation? There's a difference of opinion whether she can actually just take his money to fulfill her bare minimum needs, or does she have to go and consult an imam or an arbitrator or an Islamic judge to basically come and force the man to give the bare minimum. The vast majority of the contemporary ulama will take the latter opinion, where she has to basically take the man to an arbitrator, to a judge, to an Islamic judge, to an imam, and then he would basically judge the case and then force the man to fulfill the bare minimum needs to avoid any kind of oppression. So that covers that particular misconception as well. There's one more question here. Yes. There's an entire hierarchy of walis that will be there if, let's say, the father is not alive, for example. There's an entire hierarchy that goes. There will always be a wali. And if all of those individuals in that hierarchy are not there, then the state, the imam, the khalifa basically, from an Islamic state, will be the wali of that woman. But a woman will never be without a wali, basically. Somebody will be taking care of that aspect as well.